Good morning. Mr. Sullivan, are you going first, or is Ms. Cook going first? Ms. Cook? Okay. I had you down as you going first, but it's fine. Good morning, Ms. Cook.
Good morning. May it please the Court. We are here. I'm here on behalf of Joanne Law. I'm asking the Court to affirm the decision of the Appeals Court that rules that bills for services rendered and related to the accident are admissible as evidence of a fair and reasonable charge for the service. And I'd like to start by talking about the statute, 23379G. I think the statute, as the Appeals Court found, makes it very clear that bills are admissible as evidence of fair and reasonable charges, and also the necessity of the charge.
You talk about violating the collateral source rule, but how do we get into a violation of the collateral source rule? Because nothing about insurance needs to come in. The parties could stipulate to the amount of the medical bills, or the amount could come in through live testimony. The plaintiff could say, I paid such and such, or the medical bills can just be modified the way things are modified all the time before they're presented to the jury.
The write-off itself is a collateral source. So
I understand that, but no evidence of that has to come in if we were to rule against you.
But the problem would be then you would be crediting that write-off to the
Well, I understand that. I understand all that. But the rule about collateral source income simply says that the jury isn't supposed to know anything about insurance. So my question to you is, why does the jury have to know it? We can do all sorts of things that we do in all sorts of cases by doctoring the testimony or doctoring the bills.
The jury wouldn't have to know it, but the problem is that then it's credited against the tortfeasor's liability, which is part of the purpose of the collateral source rule. The windfall in that case goes to the defendant, who was fortunate enough to commit this tort against someone who had mass help.
Does anybody pay the full amount of the bills? Even I know that people without insurance are billed the full amount, but they don't have the money to pay it either. So
they have bankruptcy. They may or may
so they're
not.
Well, the reason they don't have insurance is because they don't have money to buy insurance. If they don't have money to buy insurance, they don't have money to pay these astronomical bills. So they aren't paying them. So virtually, I think we could take judicial notice that nobody pays the $100,000
With all due respect to my esteemed colleague, I would not take judicial notice of that. There are lots of people who come into this country and who work and who have substantial assets. I can think of several. And who don't have insurance for a variety of reasons, because they're young, able-bodied, working in various industries, and don't choose to have insurance.
And/or, with all due respect, they choose not. Some people choose not to have insurance because, other than catastrophic insurance, because the cost outweighs the benefits.
But I doubt they pay the $100,000 bill either from the hospital.
Well, I think that is the amount that they're billed, and that is the amount that they're liable for.
In this case, was there any amount for which the plaintiff was responsible above and beyond what the insurance companies paid?
It's our position that the plaintiff was responsible for the entire bill at the time she had the service.
But isn't there a statute that says that if, at least in certain circumstances, that if a provider accepts payment, they cannot bill the patient for what's been accepted by the provider?
That's true, and I think that applies. But the problem with that is if the provider accepts responsibility for this.
So in this case, we know that the provider accepted, some of the providers anyway, accepted the insurance company and were not legally permitted to go and sue the plaintiff for any excess.
That's correct.
Okay.
That's
so
correct.
Why don't we have a modified bill in these circumstances? Why isn't the provider essentially agreeing to a modified amount of the bill, and that becomes the bill?
I'm not sure what you mean in terms of a modified bill. If you're speaking about what's paid?
No, I'm speaking about the amount beyond which the provider cannot seek to recover from the patient.
Which would be the amount paid in this circumstance.
Which would be the amount paid,
Yeah.
at least in this situation.
I mean, sometimes there's a copay. Sometimes you have to pay a little bit more.
Right.
I mean, isn't this an easy arithmetical problem that if you can establish what the limit beyond which the provider cannot sue, isn't that the bill?
I don't think it's an easy problem because, and I want to talk about that, the practical problem of if we allowed evidence of the amount paid, if that's the
No, I'm
evidence-
not saying that. I'm saying you can ascertain the amount beyond which the provider cannot recover against the patient.
Or against anybody.
That's
Put it this
true.
way.
That's
So you
true.
have it's essentially a three-party contract. Let's assume it's Blue Cross Blue Shield. Massachusetts, by the way, not another state. So what the provider agrees to do is the provider can bill whatever the provider wants to bill, and there are good reasons why the provider may want to do that. But as between either the insurer or the patient, the medical provider cannot recover any more in connection with that medical procedure from anybody.
I think that's true. So
That's
long
from
as
anybody, so-
so long as that particular procedure is deemed to fall under that insurance. I think that's true.
That's correct. And if, on the other hand, you happen to have the same procedure in Connecticut, I don't know whether, and you thought it was covered, but you didn't realize that you were with Blue Cross Massachusetts, what the hospital would say, Blue Cross Massachusetts would say, I'll pay up to, let's say, $10,000 for a hip replacement. But in fact, the provider could go after you because the services were provided in Connecticut, and the contract is with Blue Cross Massachusetts.
I think that's true. I think that's
I mean,
true.
I'm pretty certain it's correct.
There are a number of
So
practical...
in that,
if I
what I'm
could go
saying, in
back-
that circumstance, you wouldn't, although the insurer may pay the patient $10,000 or no more, because the Blue Cross Massachusetts has agreed to pay the patient, the hospital could go after the patient for an excess, then you wouldn't have the Justice Spina hypothetical, because it would not be the maximum amount that the provider could secure.
You will
In that
always be able to ascertain the patient's liability. You should always be able
You can
to.
ascertain the patient's, you can ascertain the liability for past medical expenses, but the issue of what comes in at trial affects more than just past
I
medical
understand that.
expenses. It
I
affects
under-
future
But we're
medical
talking about a
expenses as
bill,
well.
the admissibility of a bill, and what is the amount that is represented in the bill for services provided up to this point.
That's correct. We're talking about the admissibility of the bill, but that bill may also be admitted, and that evidence may also come in on the issue of future medical expenses, future damages. So if the plaintiff hypothetically has to have this another procedure just like the one that she had in the future, and the jury's now been given evidence of how much that costs, now we've got to, if we're going to talk about how much that person paid for it, as opposed to this marker of what the reasonable value would be, what the bill is, then when we start to think about the future calculation, the future damages calculation, now you've got to put on a whole host of evidence to try to figure out what that would be in the future, including the problem that you have here. Here you had Joanne Law, who's receiving mass help at the time of this accident. Once she recovers a verdict, she now has money. She no longer qualifies for mass help. She may not even be able to get private insurance because of pre-existing conditions. So now we've got a situation where we put evidence in of what's paid for, say, this procedure that she had, but then we don't know how much that's going to cost in the future.
So
We
how
have
does
to
it-
bring in experts to talk about
So
that.
How does this bear on the question? The question is what is a reasonable value for the medical services? Surely the bill, the statute says the bill is evidence of reasonable value.
That's
but
correct.
The statute also permits that to be essentially attacked.
The statute permits it to be attacked, but not attacked, I don't think, in terms of the payments that have been made.
Why
The
not?
statute permits it
Well,
to be...
reasonable value is how much a reasonable person would pay to the medical provider.
And I think that it's fair for a defendant to bring in, or opposing party to bring in an expert and say, you know, Dr. So-and-so charged us $60,000 for this procedure, and no one else in the Commonwealth would do that. Here's what the charge would be at this hospital, that hospital, some other hospital. That's fair.
But not how much
why?
hospitals ordinarily ordinarily accept as payment in full?
No, not
That's not
payment.
relevant?
It's not, because then the value of
Value is somehow,
the
value is always related to payment. I
But
mean,
the-
value is always related to
The
payment. How could
value
it
then
not
is
be?
driven by
always
what
related
kind of
to value.
insurance you have.
What?
The value then is driven by what kind of insurance you have. So an injury for the same thing is different in terms of value based on.
No, it isn't.
How can you say it's not relevant
Yeah.
to the question of value? I mean, I accept that so you're disagreeing with the appeals court.
No, I don't disagree with you.
But the appeals court says they can call the providers in, cross-examine about how much did you get paid.
The appeals court says that you can bring the other providers in. It doesn't say about how much you got paid. It says that you can bring the providers in and you can cross-examine about the charges, not the payment.
What
about
do you
the
ordinarily
charges.
accept for these services?
Yes.
Well, I can't tell you that. What do you, Mr. Doctor, what do you ordinarily accept for these services?
But
That's not
then-
a permissible question?
I think that's not. I think that deals with what's paid, and I think that raises problems with the collateral source rule. It raises problems with this statute. It also raises problems.
I don't understand how it raises problems with this statute.
Yeah.
I think that this statute, my reading of this statute, is that what you're allowed to do at trial is you're allowed to bring an expert in, you're allowed to bring witnesses in to dispute the charges itself, to dispute the bill itself, but not to talk about what's been paid, because then you get into this whole issue of collateral sources.
But the analogy then would be if you have an issue as to attorney's fees, if the attorney bills $100,000 but discounts it and accepts $40,000, you couldn't offer into evidence the fact that you accepted $40,000 and you discounted it by 60%. That would not come into evidence.
That's true.
But the bill can be whatever you say the bill is. I mean, why is the bill the sole reflection of the reasonable value of medical services?
Because the bill is the only thing that we have. It may not be the best yardstick, but it is the only yardstick that we have, and it's the yardstick that the legislature chose to use when they wrote this statute.
But I mean, you're asking us to read the statute to say shall be admissible as the sole evidence.
No.
Okay, so what,
It's
if
prima
it's not the
facie
sole
evidence. It's
evidence,
not
then
the
what
sole
other
evidence.
things, Justice Cordy says, I'll bring an expert in who will say, I'm not going to discuss what happened in this particular case, but Blue Cross routinely would say we're only going to pay $20,000 for this procedure. Mass Health says we're only going to pay $12,000 for this procedure. You billed $120,000. That's well above what's a fair and reasonable cost. Is that okay?
I don't think it is, because then I think that we drive the value of the case by what kind of insurance you have. We start,
No, I'm not saying,
aside from the
in this
whole.
case, just saying in general, different insurance companies will only pay this amount, and Mass Health will only pay this amount.
And doctors routinely accept only those amounts.
And then I take it that on redirect or cross-examination, you would say, and how much do they bill for people who don't have insurance, Mr. Expert, on a regular basis? $100,000. And if you don't have insurance, and presuming you have the assets, is the hospital able to collect that? Yes. So it's only the lucky people who have insurance that get the benefit of this? Yes. And so it's in essence what then the jury says, oh, I see. Then you, in your closing argument, explain, I assume, that she may not be able to get insurance because of pre-existing conditions, and what they should do is look to see what the hospital would bill for people who don't get insurance.
I think that it could be done that way. I don't think it's what the legislature contemplated, and I think
Possibly not.
That the bigger problem is the problem that it would cause at trials themselves. I mean, this is supposed to be a very small piece of a trial that now, if we're going to have evidence of what insurance companies do, we're going to have to bring witnesses in to talk about this. We're no longer going to, the average auto case would take several days now to try because we're going to have to get into all of these other things. In addition, the other thing that I would add is that if you look at 79G alongside 23160G, a rule that would allow the amounts paid to come in is actually then more harsh than this exception that the legislature carved out for medical negligence cases. Because under that scenario, again, the bill goes to the jury after all the evidence in and the verdict is rendered, assuming we have a plaintiff's verdict. The judge then looks at that and uses the statute as a guide to reduce the recovery for medical
So
expenses.
that's a complete abolition of the collateral source rule. In other words, to the extent the insurer has paid money, that comes off the judgment.
That's correct. In medical negligence cases only, which I would further suggest that the legislature knew what it was doing here. I mean, it created this
It
exception.
abolished the collateral source rule entirely in one, and
Well, I think it partially abolished it because the plaintiff is still entitled to recover a portion of it. It's the written off amount. It's the amount that's been paid that comes off of that.
so in a
amount.
medical malpractice case, you cannot challenge the reasonableness of the bill?
Could challenge the reasonableness of the bill again under 79G,
Okay.
which gives you certain parameters to do that.
So why is that inconsistent? You can still challenge the reasonableness of the
Because
bill.
the deduction about what's paid, what happened here is Judge Zobel only allowed what was paid
I
into
understand that.
evidence. And in medical negligence cases, what happens is that is dealt with after the trial by a judge who does this within the parameters of the statute and also then is required to look at the amounts that someone paid to obtain medical insurance, co-payments. All of those things are dealt with too. And I would just submit that this is not the kind of thing that we would want to do at trial, again, because of all of the practical problems that it's going to cause, as well as the speculative nature. Because there's no way that you can put any number of witnesses on, and at the end of the day, the jury's going to have to decide as to future damages, what do they think that the plaintiff might have for health insurance in the future and might pay for some procedure.
I don't know whether that's necessarily the case. If the issue is to establish the reasonable value of medical services, I'm not suggesting that the payment of what is actually paid necessarily fully reflects the reasonable value, and the jury can look at what the evidence is and make a determination of what it is.
Well, I would submit again that we believe that the bill is the best marker, it's the best yardstick, to the extent that the legislature...
The best, but does that mean it's the most accurate? The one that best reflects the actual value of the services?
I think
in the
it's
marketplace?
the best one that we have because there's so many different variables, and because if the legislature at some point in time, healthcare is up in the air right now anyway, and we don't know.
Don't we have about 97 to 98% of Massachusetts citizens covered by health insurance?
Yes,
now?
but they all aren't. Not all citizens are covered
So
by
that
insurance.
1% should all right.
Again, this is something that it's our position it would be better for the legislature to deal with, particularly given the timing and given the fact that in another year, 6 months, healthcare may be totally different. The way that healthcare is paid for may be totally different. The legislature would then be in a position to look at the situation as it is at that time and make adjustments, just like it did with 23160G.
Thank you, Ms. Cook. Your time is up.
Thank you.
Mr. Sullivan?
If it please the court, my name is Ralph Sullivan. I represent the defendant, Daniel Griffith, in this matter. I want to begin by just noting, I suppose, the obvious, and that is that this particular case has enormous impact and interest well outside of the cases that are pending before the court. Your Honor's ruling in this case will affect the evaluation of the thousands of bodily injury claims that get settled each day by insurance companies that never find their way into court. And that is the way that claims adjusters look at medical bills and in negotiations with claimant attorneys evaluate various claims. Because the starting point of the evaluation of every single bodily injury claim in Massachusetts is the amount of the medical bills. That's where we always start in the evaluation of an
But
insurance.
you can't give
Sullivan-
us pause here. I mean, it seems that what you're asking us to do is to say, if Gantz has no health insurance and has a hip replacement surgery caused because he was in a traffic accident, then for Gantz, the medical expenses are $100,000. Cordy has Blue Cross Blue Shield. Cost to him is $60,000. Justice Spina has Mass Health. He gets only $12,000. Fair and reasonable medical expenses are going to vary among us three because we simply are insured differently?
Well, the amount of the medical bills, which if you have a certain medical bill for a certain procedure that costs somebody something different, you're going to be compensated theoretically for the amount of that bill, as is that other person that's going to be considered as part of the settlement of your case. But the actual amount that you've incurred is what's important, and that's what Judge Zobel admitted in evidence in this case.
It may be for present purposes, but what about for future? I mean, the very specific hypothetical, I don't know what is happening to Mass Health, and I don't know what's happening to the rest of the country, but you've got a Mass Health, i.e. Medicaid eligible plaintiff. She's covered. She now gets a jury award. She's no longer eligible for Mass Health, I can assure you. And she is unlikely to be able to get insurance because she's got a pre-existing condition. So, if part of what is happening here is to make sure that she is protected not only for what her actual losses, but also for future losses, how do you respond to that?
Well, I would suggest those can be predicted by way of, first of all, in this particular case, there was no evidence of any future medical treatment. It simply isn't before the court because it wasn't an issue.
No, but you've just told me that whatever we say is going to be for all cases. It's not a bad hypothetical, and you have to explain to me why, why we shouldn't be concerned about people who don't have insurance. There are lots of people who are residents of this Commonwealth who don't have insurance. And there are lots of people who don't have insurance for all medical problems because a lot of it is exempted out because of a pre-existing condition.
There's always a good deal of uncertainty when it relates to future medical bills. There's
So
always
I
the
don't mind
question-
about settlements. I really don't mind about settlements because plaintiffs and defendants can settle on whatever terms they want to settle as long as it's not violating some public policy. But when you're trying to tell a jury what to do, why if the issue is what's a fair and reasonable medical expense, right?
Yes, it is, Your Honor.
So-
And what the evidence of that should be before the court, and whether there should be an expansion of the rule as it relates, and we're talking about an expansion upon the Scott case that was rendered by this court in September, and the question of whether there's going to be an abrogation of the collateral source rule or a further extension beyond the Scott case in terms of what evidence we as defense attorneys...
No, I understand what the issue is here, but what I'm saying is it's troublesome. It's troublesome because what you're not looking at, the hospital is not being the provider. It may not be a hospital, but let's assume it's a hospital. It's not plucking a number. It's saying this is the amount of fee that I can reasonably charge somebody who doesn't have some side arrangement with me. And the side arrangement has to do, as we know, with pooled insurance more than anything else.
Well, as to the future, one can only look at the particular case and try to estimate what insurance is likely to be available to that person in the future in the event the person actually undergoes the particular procedure which is suggested, which is always uncertain. I mean, there's...
Isn't the answer to Justice Gans's question about it's unfair because one person has insurance and another doesn't, defendant has to pay different amounts, but isn't that the same as the normal tort rule? The defendant takes the plaintiff as he or she finds him or her. So, I mean, if the defendant is lucky that the person has insurance, lucky, and I mean, whatever it is, it just is.
Well, the question really turns then on whether or not the amount of the write-down is in fact part of the collateral source. And our position it is not, is that this $65,000 bill for the surgeon in this case, that the difference between the amount paid, which was $3,000 and $60,000, that wasn't a bill that was incurred by anyone. And that was not an amount that, as a practical matter, would be paid by any patient. These were damages that were simply not incurred by her. Those aren't damages that would be paid by virtually any category of plaintiffs. And to have those submitted as damages in a case where she hasn't incurred the expense is,
What do you do about the statute, though? I mean, it says in any proceeding, these and itemized bills and reports shall be admissible as evidence of the reasonable value. I mean, you've got this statute.
It does say that, and Judge Zobel, I think, in keeping with this court's decision in Phelps versus McIntyre, a 1986 decision, exercised his discretion in terms of the admissibility of those bills.
Well, he reads it, I think the appeals court is right, that he reads it as being of relevance determination, but isn't it possible, as the appeals court did, to read it to saying these are relevant and they are admissible? What else may be admissible is another question, but these are admissible.
And I think Your Honor said that in the Scott case, too. I think that's also part of the holding of the Scott case, that the amount of the bill is admissible. The question then comes on the question that Judge Gordy asked or suggested in his concurrence in the Scott case, and that is whether or not we as defendants are going to be able to be permitted to ask medical providers who may be called to testify or present evidence as to the actual amount that was paid for the particular
Okay,
bill.
but you would agree then, Judge Sobel, you're not defending this result in this case.
Well, I'm reading the decision that Your Honor's issued in Scott, and it seems to me that it's very difficult to reconcile Judge Sobel's ruling in this case with the rulings Your Honor's made in the Scott case in September. It's clear that this court has indicated that such bills shall be admissible. Of course, the judge still can act as a gatekeeper in the sense that the bills have to have some relation to the injury sustained. There has to be some basic determination made as to whether they're for some medical
Sure,
problem unrelated.
absolutely.
I think that's what the Phelps case provides. But I think what we're looking at here is what questions are we going to be permitted to ask of these physicians and medical providers when they're on the stand? I have a case scheduled next week up in Essex.
But
where
generally, the doctors on the stand are not necessarily the ones involved in billing.
Well, exactly. Or with Dr. Ozuna, the surgeon in this case, has a business administrator in his practice, and I assume that person will be called to testify if this case has to be retried.
I think that's the issue which is raised by Ms. Cook, is if we do what you want, what are we going to be doing to a typical tort case? I mean, there are some situations where it may be out of network. So if you get chiropractic, that may or may not be covered. Are we going to be going through each of the particular bills?
The amount
hip
is
replacement, chiropractic, physical therapy, acupuncture, and then have to go through each bill and say, well, this is covered, this is not covered. He was on Mass Health then, now he's on Blue Cross. He may not be in the future. I mean, are we going to be transforming a tort case into a medical insurance review?
I don't think so. It certainly will require a bit more work, but it'll be accurate in terms of the amount of the reasonable amount of the bill.
Tell me how it's going to work. Tell me pragmatically.
What are the questions you're going to ask?
Well, we wish to ask the amount that was actually, how much was the amount of the write-down on the particular bill that is at issue in this case. In this case, there's a $60,000 surgeon bill for a 4.5-hour surgical procedure, which seems to be grossly excessive. The amount paid under Mass Health, concededly, is probably below what the doctor's time was worth for that time. He received a total of $3,000.
So you're going to have an expert? I mean, I don't know. I mean, I'm really having a very hard time knowing what ruling is going to be made on a case by case. A doctor says my services are worth $60,000. You say, well, the Blue Cross insurance rate is fine, but Mass Health is a little low. I mean, who's to say Mass Health is a little low? Well, because we're going to have somebody testify as to how many physicians, how many surgeons don't accept Mass Health. You know, we've got a whole side trial going on.
Well, this has always been within the purview of the jury, and this is the way it's done in other states like Ohio and Indiana that permit the amount paid. It becomes a factual determination for the jury to make, and that is in terms of whether the optimistic high number is correct, or whether the amount paid is a correct number, or whether some number in between is the proper number. We're only asking for an opportunity to present.
The statutes in Indiana and Ohio the same as ours?
I don't know if they're exactly the same, but the notion accepted, and this is what was referenced in the concurrence in the Scott case, is that that number is permitted in evidence as part of the jury's consideration in order making a determination as to what the reasonable amount of the bill should be. And
when was this statute passed?
79G.
1958.
Long time ago.
It was.
And have defense attorneys been putting in the amount paid?
I have never done that. I'm not aware of it having been done. I think it would. My sense is that it would likely be precluded as out of concerns that it involves a collateral source. That typically a motion in limine will be filed at the start of a trial, preventing the defendant from mentioning the amount paid by any insurer. If we were permitted to do it in a way so that it didn't mention insurance, that would be satisfactory. Perhaps mentioning the amount of the write-offs that the doctor, the amount of the written-off amount of the medical bill that the doctor isn't seeking payment for. Each bill, there can be a determination made as to the amount that is payable by the patient and the amount that has been written off.
Mr.
That can be
Mr.
ascertained
Sullivan,
in
even if you
each
did
case.
that, I mean, you assume insurance, and there is a write-off. In one sense, there's a windfall somebody's going to get. And what do you say, number one, to the argument that as between the victim of this motor vehicle accident and the the defendant and the plaintiff, why should it be the defendant?
Is there really a windfall? I mean, in the sense that this
The plaintiff has paid for insurance or has done something for insurance, and I know in this case it's Mass Health, but taxpayers have paid for that insurance. I mean, so how do you figure that out?
Well, and that bill, if it's permitted in evidence without any evidence as to its reasonableness, is going to be paid by the people who pay for automobile insurance in Massachusetts. This was a motor vehicle case. So
There was a tort committed, however.
It was.
And somebody was responsible for that.
But our argument is that the difference between the $3,000 and the $60,000 that nobody pays, isn't a benefit to the plaintiff. I mean, that's simply a number that's plucked out of the air that has no reasonable relation.
You can show that the number is plucked out of the air. You can do that by showing that there's not a single other surgeon. I mean, to go back to Justice Gantz's analogy to attorney's fees, it may be pro bono. That's not the way we look at it. If, however, it's a pro bono case and you've got 16 associates who are getting their training on it, and you come in as the expert to say this is the kind of case that needed one partner and one associate, and oh, by the way, there's no partner on this kind of case, forget about pro bono, who's going to charge $1,000 an hour. The going rate in Massachusetts, the highest is, pick a number, $650 an hour for this kind of case. So you don't just pluck out the $60,000 number, you attack the basis of the $60,000, not by saying it's pro bono or we're only going to there's an agreement that I'm going to accept $10,000. That's not the way we do it.
I suppose one could bring in expert testimony to attack the bill, which is what Your Honor is suggesting. We're asking simply that we also be permitted to ask the medical provider who's on the stand how much he actually accepted.
But then why, if you're trying to establish reasonable attorney's fees, does it make a difference if they're pro bono? If there's an entitlement to, as a basis of law, that you can have evidence of what the reasonable attorney's fees is, and for whatever reason, the firm is doing it pro bono, why should the evidence of the fact that it's pro bono come in to determine what a reasonable attorney fee is?
Perhaps if it's free care or if it's pro bono, it should not. But these medical bills were not, this was not free care. This was paid for at a rate which is set forth in the Code of Massachusetts regulations for the particular procedures codes.
Yeah, so we have a lawyer who says, I'm going to charge you $10,000 for your divorce. It doesn't matter if the opposing spouse flows every motion because for whatever reason that's what I'm going to do. But when it comes to assessing the reasonable attorney's fees, why does the fact that the lawyer has agreed to cap it at $10,000 establish reasonableness?
Because I believe that if it's an arm's length transaction, assuming that the attorney isn't providing free care or free legal advice to someone, and it's a transaction that occurs in the marketplace between people who are willing and able to purchase legal services and render them, then that becomes its value because it's the price paid for it on the open market. And that's what we're looking for in this case, and that is that the amounts that are accepted by medical providers in the free market of medical services be admissible as evidence as to what the reasonable value of those services are.
Thank you, Mr. Sullivan.
Thank you.